Such an order being based upon consideration of the police report and other documents, the magistrate would not be required to meticulously examine and to evaluate the evidence and to record detailed reasons. The fact that after investigation of the case, the police has filed a charge sheet along with the material thereon may be considered as sufficient ground for proceeding for issuance of summons under Section 204 of the Code. It is the discretion which vests with a trial judge to appoint a court commissioner for local inspection under Order 26, Rule 9 of the Code of Civil Procedure. From the reasoning resorted to by the learned judge, I do not find that she has refused to exercise the discretion injudiciously. In the circumstances, the writ petition does not have any merit and is dismissed. Keeping in mind the principle enunciated under Section 465 of the Code, challenges to interlocutory orders such as a cognizance order or a summons order by raising a plea of irregularity or infraction of a procedural provision may not constitute a ground for interference by a superior court unless such irregularity or infraction has caused irreparable prejudice and has thereby occasioned a failure of justice. The court would have to keep in mind that challenges to interlocutory orders that do not go to the root of the case are a major cause for delay in the trial of criminal cases. Coming to the decisions relied on behalf of the applicant to contend that cognizance order passed by the magistrate does not reflect application of mind, in the case of Pepsi Foods Ltd. versus Special Judicial Magistrate, the proceedings were initiated by the institution of a complaint under the Prevention of Food Adulteration Act, 1964, and upon issuance of the summoning orders an application under Section 482 of the Code was filed seeking quashing of the summoning order and also the proceedings. Similarly, any compromise between the victim and the offender in relation to the offences under special statutes like the Prevention of Corruption Act or the offences committed by public servants while working in that capacity, etc. cannot provide for any basis for quashing criminal proceedings involving such offences. But the criminal cases having overwhelmingly and predominating civil flavor stand on a different footing for the purposes of quashing, particularly the offences arising from commercial, financial, mercantile, civil, partnership or such like transactions or the offences arising out of matrimony relating to dowry, etc. or the family disputes where the wrong is basically private or personal in nature and the parties have resolved their entire dispute. In this category of cases, the High Court may quash the criminal proceedings if in its view, because of the compromise between the offender and the victim, the possibility of conviction is remote and bleak and continuation of the criminal case would put the accused to great oppression and prejudice and extreme injustice would be caused to him by not quashing the criminal case despite full and complete settlement and compromise with the victim. In other words, The High Court must consider whether it would be unfair or contrary to the interest of justice to continue with the criminal proceeding or continuation of the criminal proceeding or continuation of the criminal proceeding would tantamount to abuse of process of law despite settlement and compromise between the victim and the wrongdoer, and whether to secure the ends of justice. It is appropriate that the criminal case is put to an end, and if the answer to the above questions is in the affirmative, the High Court shall be well within its jurisdiction to quash the criminal proceeding.